Lordships, in respect of yesterday's item, I'm just submitting a brief submission, written submission.
Yesterday.
That item number 12, where the
Yesterday.
senior counsel, Mr. NNB Chaudhary, had appeared. That maintenance matter. I'm just giving it. Deeply obliged. I'll give a copy to my learned senior counsel as well. Deeply obliged.
Lordship, with the consent from other side, I beg to mention item number 33, Lordship. Lordship, this matter may be adjourned for 2 weeks, Lord.
Why?
Lordship, my senior has personal difficulties today, Lordship. Taken consent.
My lord, item 33, I am appearing on behalf of the petitioner. We have filed a stay vacation petition, my lord. Lord, as he has difficulties, no problem, my lord, but date may be fixed. Otherwise, it will be difficult to get it listed, my lord.
Okay. Heard, Mr. What is your name?
You, Ghosh, Lord.
Heard, Mr. U. Ghosh, learned counsel for the respondent who prays him on the ground of personal difficulty of the conducting counsel for the respondent. Mr. T. R. Sharma,
Yes.
learned counsel for the petitioner, does not oppose the prayer. However, he prays for giving a fixed date for this case. The prayer is allowed. Let this matter be listed. 20 July.
My lord, it will be too late, my lord, because they are having interim, my lord. I have a child along with me. They have interim, and thereby, my lord, maintenance has been stopped.
Vacations are there. আগতে
19th
possible
of
আছে
June,
নি?
if possible, my lord.
আগত possible আছে যদি।
19th of June.
It will be difficult. Otherwise, we'll list it. It will not reach.
Yes, my lord.
So let it be on 20 July. We'll take it up on 20 July.
Okay, my lord. 20th of July. I'm obliged.
Wait, please, your lordship. Lordship, with consent with the other side, lordship, I beg to mention item number 2, lordship. Lordship, in this case, senior advocate Mr. H.R. Chaudhary is appearing, lordship. But today, due to he is not prepared to hear this matter, lordship. So kindly next week, lordship.
And Miss
NJ Begum, lordship.
N.J. Begum, learned counsel for the petitioner who prays for an adjournment. You have informed the
On
Yeah.
8, lordship, kindly maybe fixed, lordship, in this matter, lordship, because earlier also they have taken time, lordship.
Two.
2. 8 or 9.
prays for adjournment on the ground of personal difficulty of the conducting senior counsel for the petitioner. Learned counsel for respondent number 2 does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed. 20
It's a
July.
short date will given, lordship, because it is 22 matter, lordship.
20 is the shortest possible day.
Obliged.
Lordship, with the consent of other side, I beg to mention item number 9, my lord. My lord, matter may be adjourned for it and come up after vacation, my lord.
Why?
My lord, we need to find some more decisions in this matter, my lord.
You have informed the
Yes, my lord.
heard, Mr. What is your name?
Be secure, my lord.
B. Cycle, learned counsel for the petitioner who prays for an adjournment on the ground of his personal difficulty. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Vacation on 17th of July, my lord.
Date 17th of July.
Much obliged.
May I please, lordship?
Yes.
Item number 36. I am for respondent. Lordship, the matter may be possible for the day as my senior counsel is out of station. So,
Heard, Miss, what is your name? What is your name?
R. Deborman.
Heard, Miss. Item number 36.
Yes, lordship.
You have informed the other side.
Yes, please. Yes, lordship.
R. Deb Burman, appearing on behalf of
Respondent.
respondent. Whom you are representing? Who is your name is not there.
I am junior of
Who is the counsel, engaged counsel?
S. Hussain.
Appearing for Mr. S. Hussain, learned counsel for the respondent who prays for an adjournment on the ground that the counsel for the respondent is out of station. She submits that she has informed learned counsel for the petitioner regarding her prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed. August to the 4th of August.
Major Lordship, I will mention item number 3, Lordship. Pass over for the day, Lordship. Tenure is out of session and we concern the other side, Lordship.
What is your name?
Islam.
Heard Mr. A. Islam, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. He submits that he has informed learned counsel for other side regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed.
Date may be fixed, Lordship. I am further responding.
20 July.
Published. Order. I can really shoot.
In this case, service is completed, my daughter. As per mediation report, mediation report dated, order dated 29/1/2026. Matter may be fixed for it.
And Miss R. Begum, learned counsel for the petitioner, on perusal of office note dated 27/1/2026, it appears that the notice issued to respondent number 2 and 3 are held to be duly served. Yes. Putul. Z flag Z1 Z. No, it is not duly served. It was returned back.
Mediation order dated. The last paragraph.
What is the case?
Complaint case, cognizance is taken. The complainant and the respondents are the partner, or some misappropriation of money between them. They mortgage the property, they have a tea company. They mortgage the land, which land was sold by the accused number 1.
Return back. Stop. No. 2 and 3. 2 and 3 are returned back to the sender. As such, you have to take fresh steps. As such, the petitioner is directed to take fresh steps for issuance of notice to the respondent number 2 and 3 by speed post as well as by usual mode within 7 days of the date of this order, returnable on 22nd July. Any interim order is there? No. Okay. 22nd July. तो क्यों याद है वैसे? None appears for the applicants on call. Let this matter be listed after a week on a date to be fixed by registry. Yes, next item. Mato. Yes.
It is, Your Worship. Worship, in the last order, we were directed to take fresh steps through the local PSO. We have taken the fresh steps.
You have not taken any steps.
Okay, we have instructed, we have taken, but
No. Office note shows that. What is your name?
Worship, N. Sharma.
Heard Mr. N. Sharma, Learned Counsel, appearing for the petitioner. On perusal of the office note dated yes, you have taken. Office note dated 2/6/2026. It appears that notice issued to respondent number 2 by speed post have not yet received back. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed. 15 July.
There's an interim order.
The interim order shall continue till next day.
Identify.
Perfect. In this case, TCR was called for on several occasions, okay, and it is yet to be received.
Heard Mr. M.K. Bora, Learned Counsel for the petitioner. What was called for? Scan copy?
Yes, Lord.
On perusal of the office note dated 12/2/2026, it appears that the scanned copy of the trial court records have not yet been received. Issue reminder for the same. It also appears that the notice to respondent number 2 has also not been returned back. What is the case?
Framing against the framing of charges, Lordship, in PC account. In the meantime, trial has been progressed, Lord. There is no interim order.
Issue reminder for requisitioning the scanned copy of the for sending the scanned copy of the trial court records. Registry to take steps. You take fresh steps upon this. The petitioner shall take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 22nd July.
Item 26.
None has appeared for the petitioner on call. On perusal of the office note dated 26/5/2026, it appears that the notice issued to respondent number 2 has been duly served. Stop. Let this matter be listed again after 2 weeks on a date to be fixed by registry.
Item 27.
Who is for the appellant?
Lordship, Mr. R.P. Sharma, learned senior advocate. IA for suspension of sentence.
You have received the copies.
Yes, Lordship.
What to do?
Other date may fix, my lord.
Or to dismiss the.
That's what.
Lordship, in fact, this matter can be fixed for final hearing also because the TCR has already been received.
None has appeared for the appellant on call. Mr. M.P. Goswami, learned additional public prosecutor, and Dr. P. Agarwal, the learned amicus curiae appearing for respondent number 2 are present. Let this matter be listed after 2 weeks.
Lordship, if a date could be fixed, Lordship.
No. After 2 weeks on a date to be fixed by registry. The appellant is behind the bar.
Yes, Lordship.
Let him be there for 2 weeks more.
More much.
Item 28 and 25.
Yes.
None has a.
May I please, Your Lordship? Lordship, the instant application has been filed for summoning one investigating officer who has not been made a witness to the instant case, and I have filed this application to summon that particular investigating officer as court witness before the learned trial court. Lordship, in the instant case, the investigating officer, namely Suleiman Ali, he has arrested one He arrested the
Whether
petitioner.
records are there. Why it has come in orders column? Who are the parties? Only state is the party.
There is a stay order, madam. And now respondent number 2 is my lord, by name he was made party, ma'am.
Who is respondent number 2?
Investigating officer
Why he's
SIP Deka. Not step session. Step session here is it?
no?
Like
Why
this
he's made a party by name?
Perhaps service not complete.
No. Is there any necessity? Where is the impugn order?
Page 13.
You were the accused before the trial.
Page 32 is the matter relevant.
What is the stage of the trial?
The stage of recording statement of the petition. After the conclusion of the trial, a petition was filed by us to summon the investigating officer of the instant case, and surprisingly, he has been withheld from the case. And Lordship, the investigating officer, it is evident from the record itself, the investigating officer arrested the petitioner and presented him before the learned magistrate court 3 days after of his arrest. And while he was detained for 3 days, there is no explanation from the side of the investigating officer who has been withheld from this incident.
Yes.
Let me kindly see the page 30, my lord, observation of the court, my lord, while rejecting it, page 32. Last paragraph.
Yes, please read.
Yes.
Last.
It appears from the present petition that defense wants to examine one Suleiman Ali, who has been allegedly arrested and produced, and one accused Biddut Dev before learned magician. Though same has not been cited as prosecution witness, nor his 161 CRPC statement has been recorded by the IO. However, after perusing the case record, it appears that Suleiman Ali is not the seizure witness. Only he has arrested one of the accused, Biddut Dev, and his is a case of NDPS. And Said Suleiman Ali is not even an informant, nor IO, nor seizure witness, and his testimony will not anyway is essential to just decision of the case. If Said Suleiman Ali could have been a seizure witness or an informant, the thing would have been different. But he is not in any one of the above categories, so that without him the court can't give decision of this case. So in light of the above citation relied by me, the prayer of the defense is not tenable, as Suleiman Ali is not essential for just decision of the case. It's a very
Not in this manner. Oh, wow. Yes, you complete your submission. We'll fix it for admission next week.
loss.
The trial is stayed. Why you made the investigating officer a party in this case?
Ali is not an informant, nor IO, or nor Caesar witness. Lordship, to this, Lordship, may please turn to page number 33. This is the arrest memo of the petitioner, wherein in the last part, investigating officer S.I. Suleiman Ali, he has signed it as SI, as investigating officer of the instant case. The arrest memo of the petitioner. He is signed as investigating officer of the petitioner. Whereas the impugn order states that he is not the Caesar witness, nor IO, nor informant, which is itself contradictory. And secondly, Lordship, he has produced the petitioner after 3 days of his arrest. That is on 31. Whereas he was arrested on 27. 3 days of his arrest. And admittedly, the arrest memo also do not consist the signature of any witnesses. The point number 6 has been kept blank.
Why you want to examine this?
I want to examine because Lordship, because PW6, who is another investigating officer in the instant case, while recording his statement, while recording his evidence before the learned trial court, he has invented a complete new different facts of the story of the case, which has never been discussed in the which has never been disclosed in the FIR or the charge sheet. Lordship, may please peruse to page number 44. Page number 44, point number 2. What he stated is that search and seizure was conducted by SI Samarjyoti Deka. I arrested the accused person Bidut Dev and Jinku Das. Here he stated a concocted fact because Lordship, he is Pavitra Deka and he has, according to the prosecution paper, he has not arrested the petitioner.
It only reflects that arrest memo was prepared by.
Yes, it only thereafter, Lordship, on the next page.
Okay.
Bidut Dev pushed away. This is a new facts that has been stated by the IO for the first time before this honorable. Bidut Dev pushed away UBC Atul Hub and tried to flee away by snatching arms in Sar's rifle. The accused person Bidut Dev, being fled away, asked him to stop, but the accused person pointed the rifle towards our direction. Finding no other option, I fired one bullet, round bullet on the right leg of the accused person Bidut Dev. This is a complete new fact which has been disclosed at the stage of conclusion of the trial. There is no mention in the entire case record if the accused petitioner was shot in his leg. This is a very surprising disclosure by the IO, whereas he has not even arrested the petitioner. And a new complete sets of new allegation has been leveled against him at the conclusion of the trial. The question arises here, why? And why the said IO has been withheld, who actually arrested the person?
Trial court record. Heard Miss, what's your name? L. Banik. Yes, Mr. Goswami. Mr. Goswami. We may dispose it of today. Or we want admission hearing.
No, because the lawsuit was indicated.
Next week at the date. 12th. Heard Miss L. Banik, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. On perusal of the records, it appears that the trial of NDPS case number 220/2022 has been put to a halt by a stay order issued by this court. Hence, this criminal petition is required to be heard urgently. Let this matter be listed for admission hearing on 12th of June.
My lord,
Yes.
extremely sorry, very extremely sorry, my lord. I do 27.
If the other side comes, we will take. You are ready,
I am ready.
but we have given. You were not present when the matter was called.
There is misconception that your lordship will take up the order.
Mandate.
That's why we did.
Other side is no.
Yes. Other side.
We'll take it up on the next date.
Hello?
On the next date. Or if amicus, you have to inform the amicus.
Let it on Monday.
Okay. Kiman asile? On Monday. Monday did you? Okay, on Monday. Show the presence of Mr. R.P. Sharma.
Sorry. In item number 7, it may be fixed 20.
22 Kiman did this. After a week, it will be listed.
The date may be given.
No. Date deo. Vishek, after a week. Give a date. It will be in the month of July. 1 week, no change.
Please, your lordship, clear by fixed 15 July. However, the English council can go any date after that.
17 July.
Deeply obliged, madam. Item 31. May I please your question? My lord, as per last order, we have taken fresh steps after this. But
What is your name?
SS Ahmed, madam.
Heard Mr. S.S. Ahmed, learned counsel for the petitioner. The office note indicates that you have not taken steps.
This was accepted by additional PP 25. 7. Let me see this again.
When have you taken steps?
27/5/2026.
27?
5.
But office note dated 3/6/2026 shows that
Subsequently on 27/5, my lord, steps were taken.
27/5 is earlier in point of time or 3/6.
3/6 no.
Heard who submits that, though in pursuant to the directions of this court, the petitioner has taken steps for issuance of notice upon respondent number 2. However, office note dated 3/6/2026 shows that no such steps has been taken by the respondent. The office to verify the same and put the matter again in the next week at the date due. 12th, 12/9.
Interim order.
Yes, interim order shall continue next. Wait for your turn, not in this manner. We'll take it up after some time. You were not present when the matter was called. You wait for you. We'll call it.
Item 32.
What is the name? Heard Miss N. Kumari, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel for the petitioner is indisposed, considering the ground stated by the petitioner. The stated by learned counsel, the prayer is allowed. Let this matter be listed. The not through the sea service, again by speed post. Learned counsel for the petitioner submits that the that the petitioner may be allowed to take fresh steps as the notice sent on earlier occasion has returned without service. The petitioner shall take fresh steps for issuance of notice upon the respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July.
Item 34.
My lord, I am appearing for the petitioner, my lord.
Atul, I hope so. Yes.
My lord, I am
Next
appearing
item.
for the case, lordship. Resolution number 3 has entered.
Yes.
Resolution number 3 has entered appearance by filing Okala number, lordship, and my learned counsel is appearing for the resolution number 3 and resolution number
Sound.
2.
Computer section Manumato. Mr. Das, you are not audible. Ramesh, next item Mato. We'll take this item after some time when the
This one, item 37.
next item Mato. Next item.
What was 37?
Ramesh, computer section or Manumato. Yes.
Last occasion, Lordship asked the land PP to inquire whether the OP received by the respondent number 2 and 3, my lord. Lordship, time and again, we have served a copy upon the respondent number 2 and 3, my lord.
What is this case?
Regarding the Jima of the vehicle, my lord, there is an affair between the parties, lordship. My lord, page number 14 is the translated copy of
No,
the.
Mr. Goswami, what happened to the
It's from dispute case, my lord.
Now, we are waiting for a report.
My lord, last date, my lord, it was in the list of 2nd of June. On that day, PS Locker was there, my lord.
who are respondent number 2 and 3?
Who was the original owner of the vehicle, and 3 who purchased the vehicle from
Who has been given the
thereafter.
in whose Jimma the vehicle is?
Idle Larnet Ford below.
No, vehicle is presently with whom?
With respondent number 2.
Then notice is necessary.
Notice Lordship kindly see the.
No, you have taken steps, but service is necessary. We have
That
to
is,
wait.
last occasion, my lord, asked the PP to inquire with the OC dispute PS, my lord, whether this notice, because we have served a notice earlier occasion also in the address given in the FI, my lord.
You take
And there is
information.
Mobile number also.
You let this court know.
Lords,
Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. Though the office note dated no, it will continue. Learned additional public prosecutor has prayed for some more time to let this court know about the fate of notice issued to respondent number 2 and 3. Stop. The prayer is allowed. The public prosecutor shall intimate this court regarding the fate of notice upon issued to respondent number 2 and 3 by taking information regarding same from the officer in charge of the concerned police station on the next date fixed. How much time?
Madam, it's from Dispur PS, madam, can be next week, madam. It's a vehicle, they got the GMA in the year 2024,
23rd June.
madam.
23rd June.
Well, it's a case pending since 2024, madam. I have given 45 lakhs to this person, my lord. Still the vehicle with them, and as because
No,
Simba given to.
otherwise we are not going into question of merit now. We are only concerned that suppose this court hears it. What you want? You want back the vehicle. The person with whom the vehicle is there, he has a right to be heard.
That is why we have taken once, madam, 2/8/2024.
Short date. 17 June.
Oh, can it be on 19 June, madam?
19 June.
God bless.
Okay.
Admission, item 1. Commissioner for Lordship challenging the NI case 57 pending with the Court of Decision for Peta matter. Before that, Lordship pushed the order dated 31/3/2022, my lord. Can I receive that?
Yes.
On earlier occasion, the petitioner came before this court challenging the proceeding pertaining to NI case number so and so under section so and so on the ground that he has also filed this PS case number so and so. This sake that has been presented to the court in manipulated one and has not been issued against any liability but security which was being covered by the complainant who filed the aforesaid NI case so and so by the order and so and so. This court stayed the proceeding of the aforesaid NI case subsequently as the case was filed by the petitioner status to be ended at final report and petitioner one to contest the same by filing the contest petitions. Criminal petition was withdrawn by the petitioner with a view to contest the final report submitted by the aforesaid PS before the land in Gauhati. And the case filed by the petitioner was registered as CR number so and so, where the land trial court has directed for further investigation of the same dispute PS case number 1/2007. Minor, that minor case was directed by the reinvestigation, but reinvestigation was not neither by
No.
petitioner called
Nothing is clear to me.
I'll give the facts of this case, madam. So,
Let him. What are the facts?
Initially, my lord, I have deposited this check as a my lord, on the another person as a security bank. But their check was given only 2 lakhs, but they given one is manipulated by 1 by 12 lakhs. And thereafter immediate filed for case for the FIR loss minor. And they also
For
filed-
forging the document.
Yes, minor. Thereafter they also filed NIO.
Who filed the FIR? You. Then what happened to that
But
case?
that filed, FIR was. finally
In that case,
submitted.
FR was submitted.
Immediately might not that case is withdraw and liberty to approach before the complaint is before the CPS.
Thereafter,
CGM my lord directed to re-investigate the matter.
Thereafter,
Nothing, my lord, I am regularly attending to both the.
now why this criminal petition has been filed?
Because of that, if this, if that FIR is not completed, the investigation is not completed, in the meantime, NI is trying to keep it that matter. So now could stay in the proceeding, the last matter. In such background. petition
What,
present-
NI case has been stayed?
State matter. And parties and also, all matters proceeding, NI is the, you have a state matter. And but the police, pilot, this full police station, pilot, neither call me or anything, pilot, they reach what is the status report that can be, honorable could maybe call for, pilot.
Yes, Mr.
There are two things will be required. One, my lord, the scan copy of the TCR of the NI case that has not been called for, and the status report of the dispute PS case. Though I believe, my lord, my submission will be, the facts are that his lordship has already understood. He gave a check. According to him, it's a security check. The check was there. We deposited the check got dishonored. So we filed an NI case. Now, after the filing of the NI case, they filed an FIR, which is dispute
His
PS.
case is the check was of 1 lakh, 2 lakhs only.
That is their
You
claim.
made it 12
That is
lakhs.
their claim. my lord. No,
Okay.
that is,
Also, honorable court,
so that is an issue which my not subject to my limited understanding is something which is to be decided in the trial of the NI case. Because that is a defense plea in the NI case.
Yes.
As regards whether the check is a security check, because that plea is also there, that they've given a security check. Secondly, whether there has been any interpolation or manipulation in the check. So these are two defense pleas. Irrespective of that, an FIR was lodged after the filing of the NI case. And simultaneously, they brought a criminal petition before this honorable court in the earlier round. It's the second round of litigation.
Yes.
In the first round of litigation, initially on that round, they got a stay. In the meantime, in the course of the that criminal petition, the final report was submitted by the police in the PS case. When that matter was brought to the notice of this honorable court, the petitioner side withdrew the criminal petition. And they filed a protest
Notice petition.
before the magistrate. The magistrate directed further investigation of the case.
Okay.
Subsequent to that direction, there has been no development. I believe they are also not aware, and we have also tried our best, my lord, to find out.
What was the case? This would be a case
Full
number.
PS case number two.
Okay, okay. So status would be
Status of
required.
that, the state can produce because we have checked from the records. it's not-
State is also a party.
State is a party, my lord.
Okay. Heard,
Approve one.
Mr. N. Bora, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned counsel, learned additional public prosecutor, as well as Mr. S. Nawaz, learned counsel appearing for respondent number 2. It is submitted at bar that in this case, the scan copy of the NI case, scan copy of the,
Dispute PS case number.
no. What is the NI case?
57 of 2017.
NI case number 57/2017 would be required. Hence, let the same be called for registry to take steps for requisitioning the scanned copy of the aforesaid records from the trial court. It also appears that considering the contentions raised by the petitioner in this case, the status report of the further investigation which was directed in dispute PS case number 2122/2017 would also be required. Hence, learned additional public prosecutor is requested to obtain the status report of the investigation, further investigation, which is going on in the dispute PS case number 2122/2017. Let this case be listed again on 17th of July. Because PC can get now you were like yeah, check করে ইমান টাইম লাগে yes.
This item number 32, I misheard the date. The next date is 22 June instead of 22 July. So also in lower court, a date is fixed on this case on 24/6/26. So before that, a date may be given.
No. It will remain as it is. Commandedness. You want before,
6. 24 June. before-
but how the service will be effected before that date? 24/6 or ago 23rd. Next item. बताओ.
Item 4.
Okay.
It please, your lordship, Mr. Nawaz is on his legs in another court. May this matter be taken up after some time.
Okay.
Item 5.
Lordship, I'm paying for the
Yeah.
resolution number 1 in this case, Lordship. Lordship, after service of notice, today is listed for the first time, Lordship. So I have instruction to file affidavit in the case for resolution number 1, Lordship. For that, we need some time.
How
It may
many
be-
respondents are there?
There is a formal party also. Response number 1 is the lots of complainant.
Okay. Heard
Yeah.
Mr. J. Kolita, learned counsel for the petitioner. Also heard Mr. D. Das, appearing through video conferencing, who submits that he is appearing. You have filed Vakalatnama
Yes, Lordship.
that he needs some time to file written objection. In this case, the prayer is allowed. Let this matter be listed. How much time? Suggest
Immediately
20.
after,
20 July.
Lordship.
There will be interim motion taken.
The interim order shall continue till next day.
Lordship.
Typing item 34.
Lordship, in 34, I'm appearing for the petitioner, Lordship.
Next
Yeah.
item. Yes, 34 you are appearing for?
I am appearing for the
response
petitioner.
number 3.
And my senior colleague is appearing for the response number 3. And response number 2, though he is an informant, he is a police personnel, Lordship. He may be represented by the learned APP, Lordship. In the office note, his service is appeared to be incomplete, Lordship.
Why you made
He is an informal, Lordship.
heard Mr. Nidas, learned counsel for the petitioner. Also heard Mr.
Ardhar.
Ardhar, learned counsel appearing for respondent number 3. Stop. Also heard Mr. M.P. Goswami, learned additional public prosecutor appearing for state respondent. You can also appear for, he also appears for respondent number. He is requested to also appear for respondent number 2 as he is the investigating officer.
He is an
He
informant.
is the informant and the FIR was lodged in his official capacity. Let, yes,
And Lordship, in this case, the case diary would be required. But in the meantime, the charge sheet has been laid by the police, Lordship. So the
what have you
TCR,
challenged?
the order of the learned edition lists as 7/4/2026, Lordship.
Which page?
Page, Lordship. It's page number 66, Lordship. Page number 66 onwards, Lordship.
No. What was held in?
Lordship, the originally 48 numbers of cattle was seized by the police, and it was handed over to the present petitioner, Lordship, for care and maintenance. And subsequently, Lordship, instead of there being ample materials of cruelty on the cattle, Lordship, it has been handed over to the claiming owner, who is now accused in the case, Lordship. So, and we challenged that order before the learned edition lists, and the original order of the passed by the learned SDSM that has been upheld, Lordship. Thereafter, we are before your Lordship. Now,
You are ready for hearing?
it may, the TCR, the case diary would be necessary for this case, Lordship. And in the
Right.
meantime, Lordship, the other materials with regard to seizure and the objection filed by the IO, and the claiming owners have submitted their objection that they have submitted their receipts before the police authority, that is required to be correlated by this honorable court, Lordship. It may be listed for admission hearing, Lordship, immediately after vacation, and by this time the TCR along with the case diary may be called for, Lordship.
So, please this matter for admission hearing on 22nd July. Let the scanned copy of the case diary of Gopur PS case number 18/2026, as well as what is the PRC case number?
Case number 44 of 2026, Lordship.
As well as scanned copy of the PRC PR case number 44 of 2026
Lordship.
be called for from the trial court.
Yes, Lordship. SDSM, learned SDSM Gauhati, Lordship.
Within bracket, Court of Learned SDGM M. Gopur.
Lordship.
The registry shall take steps for requisitioning the trial court records.
Lordship.
List accordingly.
Lordship. And interim order may continue, Lordship. Interim order may continue, Lordship.
The interim order shall continue till next.
I am obvious.
Yes.
Steps has been taken to solve respondent and service is awaited.
Third, Mr. B. R. Das, learned counsel for the petitioner. The office note says, the office note dated 2/6/2026 shows that the service report in respect of notice issued to respondents is awaited. The registry is directed to place the postal track consignment report of notice issued to the respondent by speed post on the next date fixed. Let this matter be listed again on.
Fresh states.
No fresh dates. 24 July.
Can you fix on 16 July, madam?
16 July.
Item 6.
This matter may pass on for the day lordship. May fix for hearing lordship.
My lord, this submission, my lord, we are appearing for the first time today, my lord. We have not received the copies, my lord. So in the meantime, copies may be served, but if matter may come up for admission hearing, my lord, this case perhaps can be decided at the stage of admission also.
What is the matter?
It's an NIAC matter, my lord, but since we didn't have a copy, there have been otherwise concurrent findings, my lord.
Third, Miss, what is it? Miss
P. Das.
P. Das, learned counsel for the petitioner. Also Mr. S. Nawaz, learned counsel for the respondent number.
The sole respondent.
Learned counsel for the respondent, who submits that he has not yet received the copy of the criminal petition along with annexures. The petitioner is directed to furnish the same to the learned counsel within 2 days from the date of this order. And let this matter be listed for admission hearing again on 22nd July. The interim order shall continue till next day.
Madam, sorry to interrupt, madam. In item number 2, Lordship, we fix a date on 19th of June. But learned people informed that they have received the notice, my lord, report of the notice, my lord. So, my lord, they could not found the respondent number 2 and 3, my lord. So, can it be next week, any date, my lord? If possible,
Next week.
any date, my lord. Tuesday, Wednesday, any date. Because already they received. my lord. Just
Tuesday,
now.
Tuesday.
Tuesday.
Tuesday is 9. Item number? Item number 37, date from 19 to 9.
How like? Yes, 19.
Yes. Management.
Item 4, may it please your lordship.
Yes.
Lordship, I'm for the petitioner on behalf of Counsel A. Goyal. Lordship, in this revision petition, we are challenging the order passed by the Additional Session Judge Barpeta. This is a Section 138 NI case. Lordship, as per the instruction we have received, both the parties are making an attempt to amicably resolve the dispute. Therefore, your Lordship may kindly allow us some time in the petitions.
Yes.
That part will be recorded in the order.
Yes. Heard. Mr. What is your name?
Lordship P. Jala.
P.
Jala. Jala.
P. Jala, learned counsel appearing on behalf of Mr. A. Goyal, learned counsel for the petitioner. Also Mr. S. Nawaz, learned counsel for respondent number
So number 1.
1, as well as Mr. M. P. Goswami, learned counsel, learned additional public prosecutor appearing for state respondent. It is submitted by learned counsel for the petitioner that you have received the check amount.
No, they are the accused, my lord. We are the accused. So they will pay us the amount, my lord. Then we will compound it, my lord.
It is submitted by learned counsel for the petitioner that there is a possibility of amicable settlement between the parties in this case, and he prays for some time so that an amicable
The
settlement.
recovery may be made to pay the amount. Agreeable amount. By the agreeable amount. Not take the mind worse. The agreeable amount.
He also submits that no, this is not required. That there is a possibility of amicable settlement, and he prays for some time so that an amicable settlement may be reached between the parties. The prayer is allowed. Let this matter be listed on when?
After vacation, 23rd of July, my lord.
23rd of July.
Much of it.
Item 7.
May. My lord, I am for the petitioner, my lord. The case arises out of my lord's maintenance order, my lord. My lord, in the meantime, my lord, certain developments between the parties, my lord, has happened, my lord. So, my lord, I have to file, my lord, affidavit.
What? Amicable settlement?
Not settlement, my lord. Further, my lord, dispute widen, my lord.
Further?
Regarding the daughter, 9-year-old daughter. Dispute, my lord, widen. And my lord, in the meantime, in the court below, the petitioner filed for custody of the child, my lord. So I have to file, my lord, all the documents.
No, in this case, what are you impugning?
My lord, on maintenance order, it is, my lord, 20,000 per month But my lord, this by virtue of the order of this court, my lord, I am paying 10,000 per month.
Yes, Mr. Rahman.
Yes, Director your lordship, my lord. I just want to draw your lordship's kind attention to the last order passed by this honorable court that 1/12/2025, my lord. Only the operative portion I am just reading out for your lordship's kind convenience, if your lordship is placed, my lord. Land Council Mr. Sohan fairly submits that during the pendency of the petitioner is agreeable to paying 10,000 for the upkeep of the minor cell, girl child of the parties. For the purpose of the revision, this said payment may be paid from this month onwards. So, my lord, his petitioner is paying 10,000 rupees for the girl child, but I have not been paid any amount. So, in that respect, my lord, I just want to again take your lordship to the order passed in the final order, my lord, which is in the last page, my lord, page 90, my lord. Page 90, my lord.
Yes.
Part number 7, in view of the above discussions and decisions, it is held that the petitioner minor Sarkar is entitled to maintenance from the opposite party Priyanka Sarkar, and the maintenance is fixed at rupees 10,000 only per month for the petitioner and her minor girl child.
Is there any stay operative?
There's no any stay order, my lord. And my lord, he is a my lord. My husband is a my lord. I was basically a Muslim, my lord. So out of love, I fell in love with, and he is practicing the rights and issues of Hinduism, my lord.
Petitioner. Also Mr. S.S.A. Rahman, learned counsel for respondent number 2. Learned counsel for the petitioner praise for allowing the petitioner to file an additional affidavit to bring on record certain new developments which have occurred after filing of this revision petition. Considering the submissions, the prayer is allowed. The petitioner may do so before the next date fixed. Let this matter be listed 22nd June.
My lord. At the same time, my lord, he be directed to pay the maintenance amount, my lord, that earlier ordered by this court, my lord.
No, that order is already there.
Already, but he is not paying, my lord. That isn't paid in, that is pending in the year court, my lord, Udalguri, my lord. He is not regular, my lord.
You are not paying.
He is
My
not
lord,
paying,
I am
my
paying monthly rupees 10,000, my lord.
even
And
that
my
he is
lord,
not regular, my lord.
Produce the proof of your payment
Mile,
from the
mile.
next date. The
my lord, by account, because my lord, I am residing, my lord.
You-
Yes, my lord, I am in Jammu Kashmir.
no, by any method,
Wherever he can
Yes,
stay, my lord.
any mean, the petitioner shall, learned counsel for the petitioner shall produce before this court the proof of his compliance, proof of the compliance of the petitioner with the order dated 1/12/2025 passed by this court. List accordingly on 20.
Highly obliged, my lord. Obliged, my lord. Shall be so.
May it please your lordship. Lordship, this is a criminal appeal against acquittal under section 138 of Negotiable Instruments Act. So lordship, this appeal was just filed before the Celestium financial judgment came into picture, wherein it was held that the complainant would be treated vis-a-vis a victim, and an appeal may be filed under section 372 CRPC before the learned sessions court.
But now this was filed earlier.
Yes, this was filed just earlier, preceding that Celestium financial judgment. So lordship, there are otherwise similar orders by other high courts also, wherein the appeal was disposed by the high court, and then the liberty was given to the appellants to file afresh before the learned sessions. So even if that is provided, lordship, we will file fresh appeal before the learned sessions, given that that is the correct and appropriate forum now after the Celestium financial judgment.
Where is the judgment?
Lordship, in fact, Celestium financial judgment itself gave that, and after that there is a judgment by the Honorable Chhattisgarh High Court. I am just relying on both the judgments.
Third, Mr.
Y.
Y. Kothari, learned counsel for the appellant. Who submits that though this appeal was filed by the appellant under section 419 of BNSS. However, in view of the judgment of the apex court in the case of Messrs. Celestium Financial versus A. Gunasekaran, etc., reported in 2025 INSC 804, the complainant in a who is to be treated as a
The complainant otherwise is to be treated, the appellant is to be treated as a victim.
not which para?
So Lordship will see paragraph 7.9, page 31 of 35 in the Celestium judgment.
7.9.
7.9, Lordship. Towards the last end of page 31. May I read, Lordship?
Yes.
Lordship, in this context, we wish to state that the proviso to section 372 does not make a distinction between an accused who is charged of an offence under the penal law or a person who is deemed to have committed an offence under section 138 of the Act. Symmetrical to a victim of an offence, a victim of a deemed offence under section 138 of the Act also has a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing an inadequate compensation. When viewed from the perspective of an
Who is treated symmetrical to a victim?
Lordship, the complainant. The last line of this paragraph, thus under section 138 of the Act, both the complainant as well as the victim are one and the same person.
Can you explain the last line? Complainant has to be treated as a victim in the case. As such, he has a right to file appeal under section 378, 372 of the Code of Criminal Procedure as a victim. Stop. Section 372 of the Code of Criminal Procedure is in pari materia with section 31413 with which provision? Corresponding provision in BNSS
413.
413, and therefore he submits that the appellant may file an appeal under section 413 before the appropriate court, which would be a court of sessions to which the appeal would have otherwise lied had it been a case of conviction. The prayer is allowed. The appellant is allowed to withdraw this appeal and approach the appropriate court under section 413 of BNSS. This appeal is accordingly disposed of.
That liberty may be granted and some time duration may be granted. Otherwise, limitation aspect. If your Lordship will see
The
paragraph.
period spent by the appellant in pursuing this appeal may be taken into consideration for the purpose of any prayer for condonation of delay under section 14 of the Limitations Act 1963.
And Lordship, take one time also we granted that within 2 months or within 1 month. For
No.
example, in this judgment, 4 months was granted in
No,
Series PM.
we are not giving any time. You go immediately. If any delay is there, that delay would be condoned.
Lordship.
The order itself is cleared, is disposed of.
Item 10, deeply obliged.
You can take back these judgments.
Yeah, please, Your Lordship. Read petition to the filings. Read petition to the filings. It is very detailed. Okay. It is certain search for the source. That means it is other inquiries you cannot open the control size. Sorry. You know, consider to a page.
Yes. Yes, what is this?
My lord, here. In this case, my lord, the petitioner challenged the FIR as well as the charge sheet method. And the allegation is that, my lord,
It is a charge sheeted case.
charge sheet case.
What is the status of the case?
At present, my lord, charge has already framed, my lord. No,
Case is
My lord,
it has been stayed or void?
my lord, there is no state. So I am praying for disposal of this matter, my lord.
Okay.
If the respondent side, respondent number 2 is not appeared today, my lord. So it may be come up on Tuesday, my lord, for final disposal.
Whether notice has been served?
Yes, my lord, his name is shown in the M chat here. I will inform him, my lord. He may be missed the item.
Heard Mr. T. Sheikh.
I allow.
Mr.
I allow.
I. Alam, learned counsel for the petitioner. Also heard Mr. K. Basho, learned additional public prosecutor. None has appeared for respondent number 2. Though name of engaged counsel for respondent number 2 is reflected in the cause list. Let this matter be listed again
On 9th, my lord,
on 9th of
June. This. If your lordship.
admission. On 9th of 9th of
For disposal.
9th of June.
Public.
Item 11. Wait.
Procedure to 11. It's connected with the challenge to the matter complaint case. What happened, my lord, during the pendency of this case, my lord, both the parties have settled their dispute amicably. I have filed the IA in the figure. The settlement is which they have, my lord, executed by the party that has already been annexed in IA.
This matter has also been settled.
So, my lord, what happened, my lord, as the matter is pending before this court, my lord, they could not file appropriate application for withdrawal of the complaint case before a non-trial court. Full lordship, my lord, the prayer is granted. So, for the quashing of the CR case, matter will be solved on that. There is also appealing.
So I am appearing for respondent number 2.
Yes.
So they have communicated to me that they have settled.
CR case is for
Or my lord, notice was, if someone was issued. My
what
lord,
what is the matter? NIA.
the allegation, no, my lord. So, for allegation is under section 498.
You withdraw the CR case. You withdraw the CR case.
Lordship, till my knowledge, Lordship, we only
There
have
is
this.
granted issue.
Yes, they were-
No, we will allow it in view.
Yes.
We'll dispose of this, giving you liberty to approach the trial court to withdraw the CR case.
Yes.
Heard Mr. M. K. Sharma, learned counsel for the petitioners. Also heard Mr. K. Busho, learned additional public prosecutor, as well as Mr. P. K. Das, appearing for respondent number
2.
Respondent number 2. It is submitted by learned counsel for the petitioner that the matter has been amicably settled between the parties and only due to pendency of the instant criminal petition, the respondent number 2 has not withdrawn the CR case number 10/2025. Mr. P.K. Das, learned counsel for respondent number 2, has also submitted that he has been instructed by respondent number 2 to intimate this court that the matter has been amicably settled between the parties. So, in view of the submissions, this criminal petition is, we will quash the
Yes.
CR case instead of going back to that court.
No, sir.
In view of the submissions made by learned counsel for respondent number and learned counsel for the parties, there is no purpose would be served for keeping the CR case number 10/2025 pending before the trial court. Hence, considering the circumstances, the CR case number 10/2025 pending before the Court of Learned Subdivisional Judicial Magistrate Kokrajhar is hereby quashed, and this criminal petition is accordingly disposed of.
Alia, DP of learning.
The connected eye is accordingly of the closed.
Fine. All right. Item 12.
Thank you. Yes, sir. One note by your lordship on this. This is matter regarding the second marriage, father. Just I'm giving a brief note, my lord. Date, list of dates.
Then you can take it back.
Yes.
The note you have given
Dates, my lord.
earlier also.
Oh, I didn't do that. Oh, that, then it
Itu bulannya.
just list of dates. So your lordship will find, my lord,
What is the case?
case matter basically your lordship will find that just find out background matter just that will be better, my lord.
Yes.
First marriage, I opposite party, I have married her on 9/12.
You are husband or wife?
I am husband.
Okay.
I am husband. 9/12/2002. I married the opposite number 2, my. 9/12/2022, my. As per Muslim law. Your lordship of Kabinnama is there, page 58. Then, my lord, she left matrimonial house in December 2021. Your lordship can.
Yes.
21. And lodged an FIR on 31st January 2022. Right by the number under section 498A. This is in evidence stage, my. Then again, my lord, petitioner brought the opposition to back to his house in June 22 and resided together for a few months.
Yes.
On 13/3/23, she again left the house and filed one DB case, my lord. CR case, DB, my lord, that is also in evidence stage. These two cases, my lord. Petitioner filed a suit for before the family court for restitution of conjugal rights. The goal HT3 also does not count. Ceremony also does not count. This is simple, my case. Now, of course, last time our assembly has brought this. Now that by recommended practice, my lord, they have not yet it has come into effect, my lord. He was part. Uniform Civil Code. Where this is banned, my lord. Only restricted to one. Now, it is not been yet came into force by the current two. So our case is model last year, and now this has not come into effect because the assent of the governor of the President of India has not yet been given. So bill passed, it has not been yet.
What is that act is known as?
Act is known as by the.
It is still in the stage of bill.
It simply passed. It is, they are waiting for assent of the governor as well as the president of India. It comes in the concurrent list, my lord.
Okay.
Marriage and divorce. That's why president of India is also assent is required. So that is a perspective on it that cannot be.
No, but this in allegation here is before.
Before.
That.
This has not yet come into effect.
Okay.
So that just I'm saying your worship, my lord, not yet come into effect. On last 26, it was passed, my lord. It was passed in the assembly. Now it is pending for consent. This is my case, my lord.
Yes.
I think it is not at all, I cannot contain more.
So Lordship, that
Why 490? Why 83 has been?
83 is fraudulent marriage ceremonies, Lordship.
Okay, how? What is your submission?
Lordship, the wife had to leave the matrimonial house because they have two children also. One is a major and another girl is also, she is a teenager.
The question before us is whether a prosecution under section 82 and 83 of BNS can continue against a Muslim male who has married for the second time, his second wife only.
Customary law allows them, no doubt about that.
Yes.
Still now, Lordship.
Yes.
The Lordship, if we take it, Lordship, the view in that the second marriage cannot be registered without the notifying the first wife. That is also there. That is why, Lordship, it was not registered under the Assam Marriage and Divorce Act. So once it was not registered, they done it through the customary laws, Lordship. That is already stated in their petition also, Lordship. So as per that part, Lordship, it's not valid one. If we go by the leaving apart the customary part, Lordship, it's not valid. And second,
Why it is not valid?
Lordship, that it's 498, it is bigamy. Only if the customer becomes the Madam law, it is allowed. If had it been another religion, it is an offense, Lordship.
But for Muslim, it cannot. May not.
Their customs allows them, Lordship.
Yes.
But that is why it was also not registered under Assam Marriage and Divorce Act, Lordship. That is also stated by the petitioner, Lordship. And during that period, Lordship, one conjugal petition for conjugal restitution of conjugal right was filed by the petitioner. And that petition, Lordship, it was fixed for cross-examination on 1/2/2025 and 7/2/2025. But the petitioner was absent, and subsequently, he married on 4/8/2025, Lordship. It's from the order sheet what I have, Lordship, that he had filed it, but then he subsequently become continuously absent, and that is why that suit for restitution of conjugal right has been dismissed, and that thereafter he married. This second marriage was done, Lordship. But it's that intentionally he had not appeared before the court, Lordship, for restitution of conjugal right. Although it's their case that he had tried to restitute their marriage, Lordship, but from the order sheet, it looked like that, Lordship, he had not appeared there for cross-examination, or thereafter immediately he married. And why this section 82(2), Lordship, that is aggravated bigamy, Lordship, whether he had intimated about his previous marriage or not, these will come in the trial stage, Lordship. And now for that, Lordship, if it is set aside at this stage, Lordship.
What is 82(2)?
82 is aggravated bigamy. If the person hides the existence of their previous marriage from the new person or new wife.
No, where is the read 82(2)?
Marriage, this is 82(2), Lordship. Whoever commits the offense under subsection 1 having concealed from the person with whom the subsequent marriage is contracted
the fact of the former marriage shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So whether it was intimated to his second wife or not, this will come during trial only, Lordship. But if it is was or set aside, this will never, because it is with whom the subsequent marriage is contracted. See, the fact of the former marriage shall be punished with imprisonment either description for a term which may extend to 10 years and shall also be liable to fine. And subsequently, this 83 marriage ceremony fraudulently gone through without lawful marriage. Whoever dishonest
83, how 83 will be applicable?
Lordship, whoever dishonestly or with a fraudulent intention goes through the ceremony of being married, knowing that he is not thereby lawfully married, shall be punished with imprisonment of either description for a term which may extend to 7 years and
But
shall also.
his second marriage will always be a lawful marriage according to custom.
But then 82.2 is there, Lordship, whether he had intimated to the second wife about his previous marriage. Then this 83. If he had not intimated to his previous, then 82.2.
That may be.
Lordship.
But 82.2 complaint should come from the second wife.
But to know that whether she is aware of not, that she may not have that will come through during the trial stage, Lordship. First wife had filed this, but it's not nowhere stated that it is complaint from the second wife only. Whether she is that to attract that section, whether she is aware of not, that will come during the trial only, Lordship.
Okay.
So 82.2, that he had intimated that wife. She is aware of that she is the second wife. That part is there in 82.2.
Where is the affair?
Page 28. Page 31.
But in 30, in affair, there is no allegation that he has concealed the fact of first marriage. In the charge sheet, is it there? Yes, Mr. Chaudhary. 82.1 may not be applicable to a Muslim male. He can marry more than one wife. He can marry up to 4 wives at a time. But is it necessary for him to inform the second wife about the existence of the first wife?
The Lordship condition 1937. Marriage and divorce 1937 Act, my lord. Just. Section 2, my. This is till today it is protected by the Supreme Court also, my. Marriage and divorce, there is no question of my lord intimation to anybody, my. But it is not concealed, my lord. On the same day she filed the FIR. On the same day. But section 2, your condition 1937 Act, my. Shariat application Act 1937, section 2. Isn't it? Your lordship got it?
Yes.
Section 2 whether comes or not, my lord. That is second wife. And this is my lord till today, my lord. Latest
No,
news
no.
is-
Her submission is
Understand, my lord.
that even if a male Muslim man can marry 4 wives, but he has a duty to intimate
Your lordship kindly see all the decisions I have prepared. Your lordship.
as per
No,
as per
this
section
if the
82.
offense under subsection 1. Offense if I commit, then question comes back.
Oh.
Subsection, your lordship. If it is
Where,
an offense,
where?
that's subsection 2, my lord, I'm reading. This 82. 82 subsection 2.
Okay.
Your worship.
You don't have a case. You
Wait.
read 82.
82 2, my lord,
Two again.
whoever commits the offense under subsection 1. So it is not an offense under subsection 1. My lord.
Unless it is an offense.
Then how this will come by? Only once UCC comes into effect, this may come by.
Yes, Sharma.
Lordship, the customary law protects them, Lordship, that is their law.
Mr. H.R.A. Chaudhary.
I don't think your worship permits me. my lord,
Yes.
to be here.
Learned, yes, okay. Learned Senior Counsel assisted by Mr. What is your name? S.S. Ahmed, Learned Counsel for the petitioner. Also heard Miss B. Devi,
Sharma.
B. Sharma, Learned Counsel appearing for respondent number 2. This criminal petition under section 482 of under section 528 of BNSS 2023 has been filed by the petitioner Shumar Ali, praying for quashing the proceedings of PR case number 1071/2025 under section 82 within bracket 2/83 of BNS. Stop. The facts relevant for consideration of the instant criminal petition, in brief, are that the respondent number 2, namely Mabia Khatun, had lodged an FIR before the officer in charge of Gauripur Police Station on 4/8/2025, inter alia, alleging that the petitioner, who is her husband, used to torture her after her marriage, and in this regard, she had earlier lodged an FIR against him under section 498A of Indian Penal Code. And on the basis of the said FIR, Gauripur PS case number 68/2022 has been registered. It is also alleged therein that during the subsistence of the marriage of respondent number 2 with the present petitioner, he married another lady on 4/8/2025 without dissolution of their earlier another lady on 4/8/2025. Stop. On receipt of the said FIR, Gauripur PS case number 346/2025 was registered under section. Yes, you have any submission?
My lord, only one thing, my lord. Otherwise, my lord, that is the settled position of law, what my learned senior counsel has submitted, my lord. On that point, I have no, my lord, disagreement. Only I am looking, my lord, two things, my lord. Here, my lord, one thing is that the basic, what my understanding is that the basic thing is that, my lord, as because there is no, my lord, statutory provision. So as per the Shariat law or by the customary law, the marriage was solemnized. And if it is so, my lord, there is no, my lord, violations of law. Now, my lord, in Assam, my lord, what is also stated in the, my lord, petition also, page 10, my lord, regarding the Assam compulsory registration Muslim marriage and divorce act 2024, my lord. I'm just, my lord, going through that, my lord, from the gazette notifications. It is, my lord, 25th of October 2024, my lord. That is the notification that the 25th of October 2024, the Act number so and so, the Assam Compulsory Registrations of Muslim Marriage and Divorce Act 2024. Here, my lord, regarding, my lord, there is the applicability, my lord. That is the one. This act may be called as the Assam Compulsory Registration of Muslim Marriage and Divorces Act 2024. Number 2, itself extend to whole of the state of Assam. Number 3, itself come into force at once.
What it provides.
My lord, when, my lord, it at once, my lord, that what I understand is, my lord, it is immediately come into effect from the 25th of October 2024, my lord.
Assam compulsory registration of Muslim marriage.
Otherwise, my lord, I can share the notifications in the email, my it is
Yes.
not a.
Now, what is your submission?
My lord, my only submission
What
is,
it provides, what that act.
yes,
provides.
my lord. That, my lord, here, my lord, the FIR is on, my lord, that is of 8 of 25. FIR is lost on, my lord, that is 4/8/2025, my lord. FIR is, my lord, lodged 4/8/2025. And as per, my lord, Gazette notification, my lord, that is, my lord, the act come in.
No, what that act provides. Assam compulsory.
My lord, that is, my lord, regarding, my lord, that is the registrations, my lord.
Registration is compulsory.
Yes, my lord.
Okay.
Because, my lord, it has come from 25th of October 2024.
Okay.
Before that, my lord, there is no law in the state of Assam.
So, in this case, second marriage was not registered or first.
My lord, not registered, my lord. And, my lord, FIR is lost, my lord, after, my lord, that is of the, my lord.
No, we are concerned with the issue that whether any offense under 82 or 83 has been there
Yes,
or
ma'am.
not in this case.
Yes, ma'am.
Assuming that it is not registered,
My lord.
then whether an offense under section 82 has been committed.
Yes, my lord.
How?
My lord, my lord, for that only, my lord, I would like to, my lord, go through the entire, my lord, that is the, my lord, compulsory registration act, my lord. Because, my lord, if, my lord, there is a statutory provision, one, my lord, marriage, my lord, during the subsistence of.
No, you go through that.
My lord, if, my lord, again, my lord, a
No,
marriage is solemnized,
not
my
in
lord.
this manner.
My lord.
Let me reflect the,
My lord.
dictate the submissions of
My lord, my
both
lord.
sides.
My lord.
You make your submission
Only
after
that
lunch.
part, my lord.
There.
Yes, my lord.
Then we will consider.
Yes.
In the meanwhile, book will also arrive. In the second half, today. Today.
Today itself.
Okay.
Only I need to go through the act only.
Yes.
Once.
Okay. ऊपर लिखना. What was the last line? Under section 85/318 within bracket 4/82 within bracket 2/83/49 of BNS 2023, an investigation was initiated. Stop. After completion of investigation, charge sheet was laid against the present petitioner. Where is the charge sheet? Charge sheet was laid against the present petitioner under section.
Same section, 82 supposed to 80.
Which page?
Brief fact is given in page 45, last page of charge sheet.
55.
Second last page, charge sheet. Seventh line of the second paragraph.
Under section 82 within bracket 2/83 of BNS. Now at what stage trial is pending?
It was the stage of evidence.
Stop. On the basis of the said charge sheet, the PR case number 1071/2025 was registered and said case is pending before the Court of London Additional Chief Judicial Magistrate Dhubri. Stop.
Matter was stayed by
Okay.
27th.
It is
2026.
pertinent to mention herein that the further proceeding of the aforesaid PR case was stayed by this court by its order dated 7/1/2026. Stop. The learned senior counsel, Mr. H.R.A. Chaudhary, the learned senior counsel for the petitioner, submits that the section 82 of BNS, which is in pari materia with section 494 of the Indian Penal Code, provides that in the event of conducting a second marriage, a husband or wife shall be punished with imprisonment in the event, within inverted comma, such marriage is void by reason of its taking place during the lifetime of such husband/wife. He submits that the personal law applicable to Muslims does contemplate 4 marriages by a Muslim male. Stop. He submits that one of the essential ingredients for applicability of section 82 of BNS 2023 is that the second marriage should be void. However, in the case of a Muslim male, such second marriage is not void, and consequently, section 82 of BNSS is not attracted even if a Muslim male marries a second woman. In support of his submission, he has cited ruling of the Apex Court in the case of Kalim Sheikh Munaf and others versus State of Maharashtra and another. No, not Apex Court. In support of his submission, he has cited ruling of the High Court of Bombay in the case of Kalim Sheikh Munaf versus State of Maharashtra and another reported in 2022 SCC online BOM 12036. Stop. He submits that since a a second marriage by Muslim male is permissible under his personal law, the provision of section 82(1) is not applicable. And since such a act of marrying for the second time is not an offense under section 82(1), even the provisions of section 82 within bracket 2 is not applicable. And consequently, in the instant case, the provision of section 83 is also not applicable. He therefore submits that continuation of the proceedings of PR case number
071.
what is the number?
1071.
1071 slash 2025 would be an abuse of process of law, and therefore he prays for quashing the said proceeding. Stop. On the other hand, Miss B. Sharma, the learned counsel for respondent number 2, has submitted that the petitioner used to torture respondent number 2 after her marriage with him, and in this regard a case under section 498A of IPC has also been filed by the respondent number 2. The said case is still pending.
Pending, ma'am.
The said case is still pending. She submits that she fairly submits that a Muslim male she fairly submits that the personal law applicable to the parties in this to the petitioner allows a Muslim male to marry 4 wives, to have 4 wives at a time. She, however, submits that even if the Muslim male can marry more than 1 wife at a time, he is under obligation to intimate the second wife regarding existence of her first marriage, and on failure to do so, he may be regarded as having committed offense under section 82 within bracket 2 of the BNS.
Lordship, one more submission that Lordship, that although he had filed a petition for restitution of conjugal life.
He also submits that though the petitioner had filed an application for restitution of conjugal rights with the respondent number 2 before the principal judge, Family Court, Dhubri. However, after filing the said case, he had not pursued the same, and the said case was dismissed due to non-prosecution by him. What is your submission?
And intentionally he did not appear and it was dismissed, and thereafter he married. I want to say that although his case is that petitioner respondent number 2 had left the house, but in fact, Lordship, she was compelled to leave because of the torture, and although he had filed subsequently,
No, your main contention is that he should have informed the first wife.
Lordship. One way he had filed this, and when this was proceeded, he did not appear, and subsequently second marriage without.
Submits that the fact as to whether the petitioner had informed his second wife regarding the subsistence of his first marriage with the respondent number 2 can only be revealed during the trial, and therefore she submits that this is not a fit case to invoke the inherent jurisdiction of this court to quash the proceeding of PR case number 1071/2025. Stop. On the other hand, Mr. K. Bushaw, learned additional public prosecutor, has submitted that.
I have gone through that, my lord. In the, my lord, that act, my lord, there is no, my lord, rider, or there is no restriction regarding, my lord, the second marriage. Some other
Only
points are there.
registration is there.
Only registration and divorce proceedings, but it is as per that
So
only
it will
prohibited
not,
degrees of relation.
it
on
will
the
have no impact.
No impact, my lord, in this case. I have
Then
gone through that.
Then you don't have a case, Ms. Sharma.
Thing is that second marriage cannot be registered without intimating the first wife, and that is why Lordship probably.
But it will not make second marriage void.
May I read, my lord, only
Yes,
that part?
yes.
Yes, ma'am. I have gone through that, my lord. It is, my lord, that is the registration of marriage 3-1, my lord.
Yes.
I'm just reading it out, my lord. Notwithstanding anything contained in any other law, uses to contrary, any Muslim marriage solemnized within the territory of Assam, whether before or after the commencement of this act, other than a marriage solemnized under the Special Marriage Act 1954, shall be registered within the territory of the state if the following conditions are fulfilled, namely, that is the Roman 1, the first condition, a ceremony of marriage has been performed between the parties and they have been living together as husband and wife since the solemnization of the marriage. Number 2, either of the parties have been residing within the district of the marriage and divorce register for at least 30 days preceding the date of marriage. Number 3, the parties of the marriage have completed 18 years of age in case of girls and the 21 years in case of boys on the date of solemnization of the marriage. Number 4, the marriage has been solemnized on free consent of both the parties. Number 5, neither party to the marriage is incompetent or insane or of unsound mind at the time of solemnization of
What
marriage.
are the consequences of non-registration?
My lord,
Suppose
that part is also not clear, my lord. Only
Act
my
does not provide.
Yes, my lord. And because, my lord, I am because, my lord, at that point of time, my lord, that act was there, my lord. Because it is on 25, that is, my lord, the marriage was
So
solemnized.
registration
But
was
that
necessary.
is not there. That it is, my lord, that is the very, my lord, that is the mandate.
You have gone through the act.
Yes, my lord, I have gone through that act, my lord. I have gone only, my lord. One,
Yeah,
my lord, that part is there regarding prohibited degrees of relationship. My lord.
Last line. Mr. K. Bushaw, learned additional public prosecutor, on the other hand, submits that the Assam
My lord, it is the Assam compulsory registration of
Compulsory Registration of Muslim Marriage Act,
Marriage and Divorces Act
Marriage and Divorces Act
2024.
2024, which was in force when the second marriage of the petitioner was held, requires compulsory registration of marriages by Muslim persons. However, he fairly submits that non marriages of Muslim persons, marriages by Muslim male and marriages between Muslim parties. Marriage between both should be Muslim.
Yes, my lord.
in this case, there is no material to indicate that the second marriage of the petitioner was registered under the said act. He, however, fairly submits that non-registration of the such marriage would not make the second marriage void in itself, and hence
My lord, because only my lord, just I submit my lord. Here, my lord, regarding the my lord legal infirmities, only my lord two things are my lord there, my lord. The parties are free from any kind of legal disability. That is, the parties shall not be within the prohibited degrees of relationship as per the Shariat or Muslim law. That is, my lord, the legal disabilities. But regarding my lord, that is the divorce part is not mentioned.
okay, stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered the rulings of you have this second judgment of apex court, Durga Charan. Huh?
So the 25 SSC on time, SC 06.
Which para?
11.1 and 11.
Give it to me. I'll give the remaining dictation in chamber. I'll go through the judgments.
My lord.
Give the. I'll dictate the remaining part
Yes,
in
yes,
chamber.
my lord.
After going through that act also, which
My
you
lord,
are referring.
my lord.
It will be disposed of today itself.
My lord.
Next item.
Now, as my lord, learned senior submitted this act also repeal, my lord, because of the UCC, my lord. That point of time, my lord, that act was there. Now, my lord,
Yes.
UCC.
But UCC has yet
That
not.
repeal, my lord. Repeal
No,
this
but
act.
it is to yet to get the consent,
Okay.
assent.
Yes, my lord. That may be, my lord, but I have just, when I searched, it is shows that, my lord, that is repeal, my lord, as submitted by learned senior.
Okay, wait for some time.
Okay.
Item 13. The appeal has been admitted. Now, this is a bail application.
What is the offense?
354, let's say. 354.
How much was the punishment?
Punishment, conviction was for.
POCSO is there. Notice
No,
will have
POCSO
to.
is not. My learned friend is appealing.
You are for respondent number two. How much was the punishment?
5 years, maximum punishment was
5 years.
5 years with fine.
Since when you are behind the bars?
1.5 year, half year, let's say. So as on today, that is 5.
What is your ground?
Ground is, let's say, prosecution is through, let's say, they have accept the statement of the victim, let's say. There is no corroboration, nothing is there.
That is one ground. Another.
Another is, let's say, this is not a case for giving the maximum punishment, let's say, it's 5 years.
Why? Whether trial court records have arrived.
LCA report.
And LCA yet not received, my lord. Item 13.
Then let at least the records come.
Yes, PCR report. Yes.
Yes. Appeal to some. This interlocutory application heard Mr. U. Datta, learned counsel for the applicant, also / appellant, also heard Mr. K. Bushaw, learned additional public prosecutor, as well as Mr. What is your name? H. Cooley, appearing for respondent number 2. This interlocutory application has been filed by the applicant / appellant under section 430 of BNSS 2023, praying for suspension of the sentence imposed on the applicant by the judgment which has been impugned in the connected criminal appeal number 1/2025. Stop. It appears that the trial court records, though called for, have not yet been received by the registry. Let a reminder be issued for the same. Registry to take steps for issuance of reminder. After receipt of trial court records, this interlocutory application shall be considered. List this matter again. 20th of July.
Okay, 14.
And we are convicted the appellant under section 376(1) of NPC to undergo 10 years and to pay a fine of
How much punishment? 10 years.
and a fine of
Okay, what is your name?
TH Terra.
Miss T. T.H. Meram.
Of the operation of the
And counsel for. You are appearing on behalf of Mr. S. Biswas, learned legal aid counsel. This appeal under section 415 of BNS S 2023 has been filed by the appellant impugning the judgment and order dated 16/10/2025 passed by the Court of Learned Special Judge Sri Bhumi in Special P case numbers 175/2023, whereby the appellant was convicted under section 376 within bracket 1 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 and in default to suffer imprisonment in the suffer further imprisonment. Stop. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the records of Sessions case number, Special P case number 175/2023 be called for from the trial court. Let also notice be issued to the respondent. Number 2, the appellant shall take steps for issuance of notice upon respondent number 2 by what mode? Speed post. By speed post as well as by user mode within 57 days from the date of this order, returnable on 22nd July. In IA also issue notice, same. We are issuing notice, let the other side appear. List accordingly.
Right.
My lord, may I, my lord, item 15 and 16, my lord, state appeal, my lord. Kindly have, my lord, some accommodation.
Okay. At 2 I will pass order. You want adjournment?
My lord. 15 and 16.
15 and 16. On request of learned Mr. B. Sharma, learned additional public prosecutor. This when?
They may submit. Item 15, Lordship, petition was allowed, Lordship. He shall maybe call for, Lordship.
But that may be also done.
We'll pass orders at 2.
Well, okay.
Yes, 15, 16. Record. Is heard, Mr. This is a leave application.
Leave granted.
Leave was granted.
My.
15. 15 and 16.
16 is also there, separate. Appealing is secretarial.
16 is a different case. Different case.
State.
Okay. Heard Mr. B. Sharma, the learned additional public prosecutor. You are Mr. Chetri, you are appearing for?
Respondent, sole respondent.
Also heard Mr. Beach.
SK Chetri.
SK Chetri, appearing for the sole respondent. This appeal referred by the state of Assam has been directed against the judgment and order dated 24/1/2024, passed by the Court of Learned Additional Sessions Judge cum Special Judge POCSO, Kamrup Metro, in session special case number 225/2024, whereby the respondent was acquitted of offenses of charges under section 365/376 of the Indian Penal Code, read with section 6 of the POCSO Act. Two 2012. Stop. We'll admit the appeal. The appeal is admitted. Let the records, since the sole respondent has already appeared, no formal notice need to be issued. Let the records of the trial court be called for from the trial court. Registry to take steps for requisitioning the records. Let this matter be listed.
So a copy may be given to us. Member of appeal is not sub to us.
24th of July. The London Additional Public Prosecutor is requested to furnish a copy of the memo of appeal along with annexures to the learned counsel for the sole respondent. 16, Mr. Goswami, you are appealing.
This
This
state appeal, my
leave
appeal against leave granted.
Okay.
Leave well.
Heard Mr. M.P. Goswami, learned additional public prosecutor. This appeal under section 419,
Yes, sir.
419
419-4.
of the
Bharati and Agarwal.
BNSS has been preferred by the state of Assam, impugning the order dated
17.
judgment and order dated 17/12/2025 passed by the learned special judge Dima Hasaw Haflong in special POXO case number 6/2023, whereby the two respondents, whereby the respondents / accused persons were acquitted of offense under section 366/376 of the Indian Penal Code, read with section 6 of the POXO Act 2012, as well as section 4 of the Child Marriage Prohibition Act. Prohibition or Restraint?
Restraint Act.
Child Marriage Restraint Act 1929. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days of the date of this order, returnable on 24th of July. Let the records of the trial court be called for. The registry to take steps for requisitioning the records. List accordingly.
Item 17.
It's to be appealed, okay? That the appellant convicted under section 6 of POXO Act for 10 years.
6.
6.
Heard Mr. I.U. Chaudhary, learned counsel for the appellant. This appeal under section 415 of the BNSS has been preferred by the appellant Anwar Hussain, impugning the judgment and order dated 24/4/2026 passed by the Court of London. Additional Session Judge cum Special Judge POXO, Morigaon, in POXO case number 17/2019, whereby the appellant was convicted under section 6 of the POXO Act 2012 and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 15,000 in default, to undergo simple imprisonment for 2 months. I have gone through the grounds taken in the memo of appeal. This appeal is admitted. Let the notice be issued to respondent number 2. The appellant shall take steps for issuance of notice to the respondent number 2 in the manner as prescribed in the prevailing notification in this regard. Prevailing notification of the registry in this regard. Stop. Within 15 days from the date of this order. Returnable on 24th July. Let the records of the trial court be called for. The registry shall take steps for requisitioning the records. List accordingly. I also issue notice.
Item 20.
This is also appeal against conviction. So section 8 of the POXO Act and also.
Heard Mr. J. Ahmed, learned counsel for the appellant. Also heard Mr. B. Sharma, learned additional public prosecutor. This appeal under section 415 of the BNSS has been preferred by the appellant. Impugning the judgment and order dated 6/5/2026 passed by the Court of Learned Special Judge Bojali Patshala in Special POCSO case number 11/2022, whereby the appellant has been convicted under section 365 of the Indian Penal Code and section 4 of the POCSO Act 2012. He has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 with default stipulation under section 4 of the POCSO Act 2012. He has also been sentenced to undergo rigorous imprisonment for 4 years and to pay a fine of 5,000 with default stipulation under section 365 of the Indian Penal Code. Issue notice to the respondent number 2. The appellant shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on 27 July. Let the records of the trial court be requisitioned. The registry to take steps for requisitioning the same. List accordingly. I notice, issue notice.
Item 19.
We have resolved. Notable the law application the city has been performed. And it's wrong.
My lord, case diary received in the record, my lord. But one thing is that, my lord, forensic report, because my lord is a case of fake currency.
Fake currency.
Fake currency. My lord, the forensic report is not in the record, my lord. I have said that will be necessary, my lord, because all
Is there a scan copy has arrived or?
arrived. The scan copy arrived.
The investigation is over or it is going on?
My lord, actually, regarding charge sheet, my lord, there is no mention.
Is it a charge sheeted case?
Under investigation.
Under investigation.
Yes.
Then why scan copy has come? Original case diary may come.
Original case diary may be called.
Because their forensic laboratory report may be there.
Yes.
What is your name? Write his name. Learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public prosecutor, who submits that though the scanned copy of the case diary has been received, however, it does not contain the forensic laboratory report. He prays for some time to get the copy of forensic laboratory report. The prayer is allowed. Why this criminal petition has been filed? Challenging.
On 30 of July 2020.
Quashing the FIR.
Quashing the FIR.
Okay. Then original case diary may be required.
Case diary may be called
Let
for.
the original case diary be called for.
Yeah.
Learned public prosecutor, additional public prosecutor is requested to produce the original case diary before this court on the next date fixed. Let this matter be listed 27 July.
Budget 20.
My pleasure, Lordship.
Yes.
Your
Yes.
Lordship, the present matter is pending before the Honorable Child Court, Bojali, at the stage of consideration of charges.
Okay.
Your Lordship, this is a charge sheeted case. And Your Lordship, in this present matter, an FIR was lodged at Patshala in the year 2024, alleging the discrepancy of 63 command certificates of Home Guard volunteers. And I have been falsely implicated in the present case only on the statement of the co-accused. No prima facie was made out as there has been no recovery whatsoever from me or any incrementing document nor monetary transaction can be seen.
This is item number
20, Your Lordship.
20. Where are you now?
Your Lordship, from the chamber.
In Gauhati?
Yes, Your Lordship.
Okay. Then we will we'll admit the matter and we'll hear the matter. Will it be possible on your part to appear personally?
Yes, Your Lordship.
Okay. Yes, Mr. Sharma.
Well,
We'll admit it
well,
and fix it for hearing on a short date. What is your name?
N. Hussain, Your Lordship.
Heard Miss N. Hussain, learned counsel for the petitioner appearing on through video conferencing. Also heard Mr. B. Sharma, learned additional public prosecutor. This criminal petition office note dated 1/5/2026 shows that the scanned copy of the case diary which was called for has arrived. This matter is therefore admitted for hearing. Let this matter be listed for hearing on 30th of July.
Highly obliged, Your
List
Lordship.
accordingly. Yes.
Please adjourn the matter for today as
Why?
passenger is out of station.
Yes.
Yeah, no objection. But Lordship, on last day, they are directed to furnish annexures type copy because most of the annexures are in a state that we cannot read it, what they have written.
You have not yet furnished. Okay. What is your name? J. Sangma. Miss J. A. Sangma, learned counsel for the petitioner. Also heard Mr.
BJ Das.
B.J. Das, learned counsel appearing for respondent number 2, as well as Mr. M.P. Goswami, learned additional public prosecutor appearing for respondent number 1. Learned counsel for the petitioner has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. On the other hand, learned counsel for respondent number 2 has submitted that he has not yet been furnished with the legible copy of annexures as was directed by this court by its last order. Learned counsel for the petitioner undertakes to furnish the same within 2 days. Let this matter be listed again on 20th of July.
Item 35.
Yes, Mr. Datta.
Lordship.
What is this?
Lordship, it is appeal against conviction, Lordship. But on last order, Lordship, kindly.
Who is for the?
Lordship, one Anishu Alam,
Oh.
he was representing. On last occasion, Lordship, last 2 order, Lordship, he has submitted before his honorable court And that matter would be amicably settled between the party, and the entire amount will be deposited in a 6 installment. And also give a undertaking before this court that first installment of 50,000 will be deposited within a 1 month, Lordship. But that was order passed on 30 April 2026, but till today, Lordship, neither any assured amount nor the council is present.
Is there any stay?
Lordship, stay, Lordship.
Stay is there?
Stays there. Some-
What should be done? What is
Lordship,
this?
another date may be fixed, Lordship. Otherwise, in his absence,
None has appeared for the petitioner on call. Heard Mr. P.P. Datta, learned counsel for respondent number 2,
respond number 2, Lordship.
who submits that though on last occasion it was submitted by learned counsel for the petitioner that the petitioner may be directed to deposit rupees 6 lakhs within a period of 6 months. And accordingly, this within a period of 6 months.
6 months, Lordship.
So that 6 months has not yet lapsed.
No, but within a 6 installment, Lordship, he was required to clear all this amount of 6 lakhs rupees.
And accordingly, the court directed as the petitioner to do so. However, no, stop. The court also directed to directed the petitioner to deposit an amount of rupees 50,000 within a period of 1 month of the date of the order. Stop. However, learned counsel for the respondent number 2 submits that no such payment has been made by the petitioner in pursuant to the said direction. Stop. However, learned counsel for the respondent number 2 fairly submits that since the counsel for petitioner is absent, one chance may be granted to them. The matter is accordingly adjourned for the day. Let this matter be listed on 4th of August.
Next week, can we not try Lordship next week? For payment.
June or last week.
Hearing no hoy na.
Not for hearing.
Hearing no hoy ne, just payment to pamo.
30 June.
30 June to bono. 13, 1 3. 3 June will be holiday, Lordship.
29 June.
Okay.
Finish.